Kooti eragire mwami Kyagulanyi ne mukyala we amaka gaabwe gaggulwe batambulenga bwe baagala. Mubadde mulaba omukyala nga takkirizibwa na kugenda kusima lumonde we. Abapoliisi n'ab'amagye bali mu lumonde wa Kyagulanyi bameketa. Tebaagala Kyagulanyi agende mu nnimiro ba mukyala we. Abaana baabwe n'abakozi baabwe aba bagenze mu nnimiro babakuba bukubi, tebabakkiriza. Mwami Kyagulanyi takkirizibwa wadde okusisinkana balooya be okuggyako abapoliisi beesazeewo okumukkiriza nti ligenda olabe gundi tumukkiriza, abalala tubagaanye. Takkirizibwa kukyaza abagenyi be. Mwalabye n'ababadde bamutwalidde emmere bannaffe okuva mu American Embassy n'abakulembeze abalala ba National Unity Platform tebakkirizibwa mutwalira mmere. Nti kwegamba Museveni akwatibwa obujja ne ku mmere gye weerimidde oba mikwano gyo gye bakuwadde ereke kutuukako, enjala ekulume ofukamire ogambe ssebo nkuyozaayoza obuwanguzi. So tuzze mu kkooti okusaba kkooti eragire bannaffe baggulirwe babeere n'emirembe. Bawadde ensonga 3 ezikontana lwaki munnaffe bamuggalira. Sooka bagala bo tebamuggalira, bakuuma mukuume kwaba abandi mutuusizzaako obulabe. Ekyokubiri ne bagamba nti olw'okuba mu kampeyini yeeyisa bubi n'abeera n'abawagizi bangi, ekyo kimuganyisa okufuluma. Ne bagamba musajja mumenyi w'amateeka ne bwe yali mu kkomere Nalufeenya yeenyigira mu kukyankalanya emirembe mu Uganda. Eri ng'ali mu kkomera, eno ng'ali mu kwekalakaasa okwetooloola Uganda yonna. Ezo z'ensonga zaabwe. Ne tugamba nti mussemateeka tebalina buyinza omuggalira mu amaka ge si kkomera. Tebalina buyinza bugaana bantu be yeetaaga kumusisinkana. Tebalina buyinza bumugaana kutambula na kwetaaga. Olunaku lw'ebbalaza nga 25 essaawa 3 nga lwe tujja okufuna ensala ya kkooti. Tusabire byonna Mukama ajja bikolako. Nyiddwako ddirwe ekyakolebwa ate nga bakyokya bwokya ne bakiweereza Attorney General ne bakitwalira komishona nti ekirayiro nti akiteekeko omukono ng'eyaliwo nga balayira. Tukiwakanyiza era omulamuzi ajja tubuulira kyakirowoozaako. Mwami Okyom byayogedde byonna tabimanyi. Bagambye nti ba DPCs be baaliwo ng'ono akola byakola. Abaganda balina kye bagamba nti mpulira byogere ng'engalabi ya Nyanzi. Engalabi ya Nyanzi yeewulira ebyogere n'ebitambuza nga bweyagala. Saagala gamba nti bino bivudde mu ngalabi ya Nyanzi, bivudde mu Okyom.
Council
Liberty, then they should concede to the application. Because in this application, they are actually justifying the restriction. If you read the entire affidavit, it is saying his liberty is restricted. But I will begin with paragraph 4, which you guided well, my lord. Paragraph 4 states, I know that the first applicant, Honorable Kyagulanyi Ssentamu, is not under police custody. He is at his residence with the police giving him the necessary protection. That is the first. Number 2, which is paragraph 5, that the movement of the second applicant, Barbara Kyagulanyi Tumbu, and the other members of the household have not been restricted in any way. That answers the question which court posed as to whether the movements of the first applicant are restricted. They are saying they are not restricting the second applicant in any way. When it comes to the first applicant, they agree his movements are restricted. When you go further with the affidavit, first, my lord, let me point out, procedurally, ordinarily, this would have been an ex parte application, where the respondents would only come in to justify. And that justification would only be preceded with compliance. You produce the body and justify. But now taking whatever the worth of their response, that they are not restricting him, he's not in detention. I know that the first applicant, that is paragraph 6 of Edward Ochom's affidavit, has on several occasions organized processions and addressed mass gatherings in several places contrary to the public health control of COVID-19 regulations. And he goes on to explain in justification of the restriction. And you will find a very stern contradiction between paragraph 4 of the affidavit of Edward Ochom, trying to justify, to deny that he's not in detention, but he's only protected. Against who is not mentioned. When you read all the other paragraphs of his affidavit, they are justifying, first, COVID-19 rules. And I'm just explaining a summary of the affidavit. The second justification is that the Honorable Senator Kyagulanyi jumped bail on 18th December 2018, and that's paragraph 15 of the affidavit. By necessary implication, they are trying to do that to help court which granted him bail, that he jumped. He has not attached a record of proceedings of court and which court it is of 18th December 2020. Do you hold someone incommunicado, and for how long? Do you detain somebody in his house, which is an ungazetted detention center, and for how long? The summary of it, my lord, is about due process. First, the police, in this case, is the complainant. Against the applicant's purported criminal conduct. But they have also turned themselves into judges that even determine the sentence. And that sentence is detention in one's home for an indefinite period. My lord, the same people who are saying the man is not in detention.
What is the allegation? When is this supposed to be?
My lord, first of all, he's not supposed to be detained.
No, but in your application, that is the whole crux of your application. So when you say his liberty was curtailed, what was the first day that his movements you say were?
Several people who have tried to access the applicants or their home, including myself, that is the deponent, and his lawyers have been denied access. And in response, paragraph 24, the person who is not detaining the applicant says, in further response to paragraph 19, two of his lawyers, known as Mr. Mpuga and Wameri, requested to meet their client and were not refused the entry. First requested. Why would I request the police to access my client if my client is not restrained and is not detained? The applicant, however, declined to talk to them, insisting that he preferred talking to the whole team of his lawyers altogether. This is is the same person saying the man is not restrained. But even his lawyers, to be able to access, first they must request. And two, the respondent must choose the number and names of the lawyers to access their client. And I'm sure court will agree with me that this thing is not called an affidavit. To begin with, it is an undated document scanned not even a photograph. My lord, it is scanned. I don't know if yours is different from mine. But in any case, we are supposed to have the same copy. It has no date. You see that the signature itself is scanned. As opposed to the commissioning signature at the last page, page 9. It is incontrovertibly evident that this undated document was not signed before the purported Commissioner for Oaths, Jackie Okot. Article 44 of the Constitution is non-derogable. There are two rights that are non-derogable in as far as this application is concerned. Under Article 44C, my lord, C and D. The first is the right to a fair hearing, and the second is the right to an order of habeas corpus. With respect to fair hearing, I have stated, my lord, that Mr. Ochom is seeking to justify the continued detention of the applicant. And they use, you do not condemn somebody and pronounce penalty to him, which is not known in law. Assuming, my lord, these so-called NUP supporters existed and are in a riotous mood for the next 10 years, would Kyagulanyi be in detention?
Is that something that we should be addressing on from the bar, or you should have raised any?
No, my lord, I'm referring to the affidavit because it is the justification they are placing before you.
And that's the justification which appears in King's affidavit reply. We could narrow it